Welcome to Government Contracting Weekly, sponsored by AOC Key Solutions Incorporated. Government Contracting Weekly is the only television program devoted exclusively to the competitive and dynamic world of government contracting. A world where coming in second place is not an option, but where principle-centered winning is the only approach.
Good morning. Welcome to Government Contracting Weekly. I'm Jim McCarthy, the owner and technical director of AOC Key Solutions, and the host of this program. I have been directly engaged in government contracting industry for more than 30 years, and I'm sad to say there has never been so much of a well-deserved level of concern about violence in the workplace as there is today. Now, as our regular viewers know, this program is all about helping government contractors win and retain federal contracts. So why, you may ask, are we devoting today's show to violence in the workplace? The answer, as our distinguished panelists will help us see, is that the time is fast approaching when your company's ability to demonstrate the steps you've taken to provide the safest possible workforce could have a direct impact on your win ratio. Joining me today are three experts in the area of workplace law. First, we have Spiros Komis, the General Counsel for C2 Essentials. Welcome.
Good morning, Jim. Happy to be here.
Go ahead. And then next I'd like to introduce Lori Turner, who is a partner in the firm of Eisler and Dare.
Good morning, Jim. How are you? Thank you for having me.
You're welcome. And rounding out our panel, last but not least, is David Miller, the General Counsel for SkyLink Aviation. Good morning, David.
Good morning, Jim. Happy to be here.
Okay, so workplace is a really serious subject, and there's a lot to cover, so let's get right to it. My first question, I think maybe we'll direct it towards you, Spiros, is let's define the term. What is workplace violence? I mean, it seems obvious, but it's more than that, right?
Well,
Yeah.
Jim, I think that with the devastating event that occurred at the Navy Yard last year, contractors and really all employers were put on notice as to heightened sensitivity of what the workforce environment means as far as risk and liability. Workplace violence is not just overt acts of violence. It's acts of discrimination, harassment, sexual or physical or otherwise. It's threats, intimidations, bullying, anything that could create a tort that cause liability for the employer or harm to the public.
So there's a lot for the contractors to consider other than just an active shooter, in other words, right?
Absolutely.
Okay, Lori, how has workplace violence impacted small businesses, large businesses that are contractors in this arena?
So I think it's challenging for a government contractor because you're not in control of the workspace. So, you know, oftentimes your employees are on a government work site and, you know, you don't have any control over how the government's monitoring their own people and the security. And then you're also dealing with, you know, employees that are employees of other government contractors. So I think it's tough because you don't really know what policies the other government contractors or the federal government have in place as far as workplace violence goes.
Jim, can I just say that the Government Accountability Office did a study about 2 years ago and advised that the annual impact, financial, economic impact on the private sector is approximately $40 billion a year.
With a B.
With the billion with the B, because of, like Spiros was talking about, the entire generic impact of workplace violence. $40 billion.
Okay, so Dave, given all those things that our colleagues have said, what do you think is the single most important issue that's impacting contractors in this arena of workplace violence?
I think it's twofold. I think number one, potential liability, because all employers, whether you be public or private, a government contractor or not, have what lawyers call an affirmative obligation to provide a safe workplace. And I think you're going to see more and more insistence on the part of the government that you have adequate training programs to sensitize employers and managers and employees to all forms of workplace violence.
I see. Okay, Spiros, you can add
And I want to
something.
add on to David's point. I think a little bit more tailored to an employer's obligation are the issues of hiring, retention, and termination. An employer could be negligent in the way that he hires employees, and so with regards to the background of an individual, is the employer on notice of any propensities or actual records of violence that could create liability? And the same applies to retention.
So talking about propensity, if you will, are there any kind of telltale signs, red flags that perhaps are typical in the workplace, that there's a problem, there's a ultra troubled employee that's about to cause problems? What do you look for?
I would say that there's not really any telltale signs, but some of the signs are the person's acting different than what they're used to acting. So if someone's really outgoing in the workplace on a general basis, and then all of a sudden they become introverted, I mean, that would be a sign, or vice versa. For example, if they've been counseled on something like absenteeism and they can't drop it, so they keep, raising complaints about something else in the workplace, or filing complaints about their coworkers, something like that, or if they become argumentative. Some other signs are if they take up a sudden interest in guns or weaponry or something like that. I think those would be sort of the signs.
Sometimes when these tragic incidents happen, I guess with the advantage of hindsight and a rearview mirror, you say, oh, I should have known. Those signs were there, but somehow we tend to rationalize them or don't look at them, and that's what causes the problem. So be alert, is what you're saying.
And Jim, and also to that point, I think, and you actually raised it, you have to know your workforce, which means as a manager, as an executive, you really have a duty to really go down to your people, talk to your people, communicate with your people, have a real sense as to what's going on in their lives. So it has to be an active management.
Okay, so you mentioned active management, so let's talk a second. What are the obligations that a government contractor has to protect its workforce? Is it under wraps to make sure that it does everything right? And let's say some nut comes in with a gun. Is the government contractors, are they liable for that?
Can I say that first of all, to that extent, the active shooter situation that you're talking about is relatively small. I mean, they're highly publicized by the media. They're obviously very tragic. But net, given everything that Spiros talked about in terms of workplace violence, it's very, very small.
Very small.
Having said that, I don't think there's any difference in liability with respect to whether you're a government contractor or not. You still have what lawyers call an affirmative duty to provide a safe workplace for your employees. And if you do that, you obviously can be sued, okay, on basically a negligent basis.
And I want to add on to David's point, it's not just a safe workplace for your employees, it's a safe workplace and also environment for third parties in the public.
That's correct.
And this is the issue for our contractor clients, where you're either at a government site where you have non-workforce employees, whether they're with the government or a subcontractor or a prime contractor, your obligation is affirmative as to those parties as well.
Right. Okay, so talking about obligations, and we're running a little short on time here for this, but a quick answer. The Equal Employment Opportunity Commission has issued some guidelines. What are they about? Can you explain that real quick?
I'm happy to take it.
Okay.
Sure, certainly. So the EEOC came out in 2012 with some guidelines that are concerned about background checks, people running background checks. And so their big concern is that background checks have a disparate impact on different classes, namely race. So it would be, Hispanics or, African American population. So the EEOC, before you run a background check, they want you to make sure that you're running it for a legitimate business reason. And so what you need to do is, they call them the green factors. And the green factors are, when you run a background check, you look to see whether, the conviction, what was the nature of the conviction, and then what time has passed between the conviction and the job that the person's applying for, and then you look at the nature of the position that the person is applying for.
Thank you, Lori. We're going to break for a commercial now. When we come back, we're going to continue exploring this subject.
Great, thanks.
Okay.
Working in contract management is a complex job. Creating, executing, managing contracts. It's an ever-changing world, and our members share the same challenges. At the National Contract Management Association, we know this business, gathering the best minds in our field, furthering your career by providing knowledge and training. Together, we've figured it out.
So, did we win that government contract?
We did. And now we've got to deal with the regulatory hurdles.
Well, good luck with that.
When the government's your client, you need to play by their rules.
And the rules change more than you think.
Exactly. We need someone who's done this before. Plus, it's complicated, so we're going with BDO.
BDO?
People who know government contracting know BDO.
Question for you. Do you lack an overall effective win strategy? Hi, I'm Jim McCarthy, owner of Key Solutions. For over 30 years, KSI has helped clients win or retain over $130 billion in government contracts by providing the keys to winning. Now, if you're chasing a must-win contract, go to our website, aockeysolutions.com, and click on Win. It's a tough market. Don't go it alone. Okay, we're back now. Spiros, I have a question for you. Let's talk about allegations, possibilities, potential. If there's an allegation or possibility of a threat or a danger to employees or public, what are the obligations of the contractor under that situation?
Contractor has to be extremely responsive to threats or possible violence. Instantly initiate an investigation to determine whether the allegations are credible. If they are credible, the contractor needs to take instant action to protect not only the employee from themselves, but also the other employees and the general public. This could be paid leave, unpaid leave, administrative leave pending the investigation, and so forth. But the key, and as David highlighted, is responsiveness, know your workforce, and take critical action quickly.
Okay, so the key is to act.
It's to
You
act,
have
but
to
also,
act.
but also too, Jim, it really is a question of judgment. I mean, a lot of this are really judgment calls. And getting to Spiros' point, you've got to investigate. You have to objectively look at the evidence. But at the end of the day, also as Spiros pointed out, the bottom line, the paramount concern has to be safety. Safety of the workforce, safety of the employees, safety of the public. So at the end of the day, the primary consideration has got to be, the overriding consideration has to be safety.
But how grave does a threat or the potential threat have to be in order to pull the plug on somebody? In other words, in order to dismiss them or send them home or something? I mean, is there some cliff, some guideline?
I think it's always best to err on the side of caution when it comes to protecting, at least in the short-term time. With regards to terminations, the employers and specifically contractors need to be careful to protect themselves against claims of wrongful termination for claims that are not substantiated, and this could include claims of defamation. You made a threat that I said this when in fact I did not make that threat, and I was terminated because of it, and now I have damages.
And I also think you need to be consistent in your termination, so you need to look back and say, if you're going to terminate somebody, look at past terminations, look at past disciplines for people that have engaged in similar conduct, because you could find that you've by terminating someone one time but not doing it in the past, that you've now got yourself in a wrongful disparate treatment claim, so that somebody's going to say, hey, you treated this person differently because of given some protected classification, race, color, religion, whatever it may be.
So while you're on this subject, I mean, obviously everybody's aware of the tragedies that took place, let's say at the Washington Navy Yard and Fort Hood and so on. So it raises the question of mental health. And so, Lori, tell me your thoughts on what are the contractors' obligations in this whole area of mental health?
Sure. Mental health is actually kind of a tricky subject, because a lot of times mental health, mental illness will be covered under the Americans with Disabilities Act. So you've got to be careful that, if the person is truly mentally ill, an accommodation for this person might be giving them time off, allowing them to go seek treatment, and then come back into the workplace. So, and then you also have another concern of, if they're not really mentally ill, that you've regarded them as mentally ill. So the ADA, the Americans with Disability Act, has a claim, that someone could make that you've regarded me as being disabled, and they can, try and file some sort of charge of discrimination lawsuit
when
on
in
that
fact
basis.
I'm not
when I'm
disabled.
not, exactly, but you've regarded me as that, and now I'm bringing a claim against you for that.
And Jim, also to that point, I think Lori raised some excellent points. I mean, obviously mental health, very sensitive issue. Having said that, I think as an employer, putting again the forefront of the safety of the employees and of the workplace being number one, you need to document number one. Number two, I would actually bring in an outside party. By that, when I have a sensitive issue like this, I always bring in outside counsel, an unaffiliated party, somebody that can look at this thing perhaps a little bit more objectively than I could. So in a situation that Lori was talking about, I'd look at the evidence myself, but invariably I'd bring in an outside party to objectively review.
Okay, Spiros.
And to add one point, for our government contractor clients in our audience, this problem is compounded by the fact that whether you're a prime or subcontractor, whether the government itself is the customer, they may say, remove that individual.
That's correct.
And at that point, you could be in violation of the ADA or rights
Family
under
Medical Leave Act,
FMLA,
if they're entitled
and thus
to leave.
exposed legally.
Exposed illegally over a decision that you have very little control out of.
Okay, well, we're going to take a break and step away, and we'll be back in just a second.
Great.
Questions. Do you lack win strategy, themes, and discriminators? Are you being outmaneuvered by your competition? Did you get a late start on your proposal? If you answered yes to one or more of these nightmare scenarios, we can help. Hi, I'm Jim McCarthy, owner of Key Solutions. We help government contractors win government contracts. And for over 30 years, KSI has helped clients win or retain over $130 billion in government contracts by providing the keys to winning. We assist companies both large and small to enter the U.S. government contracts market or to increase their market shares. We have worked with 87 of the top 100 government contractors and literally hundreds of small businesses. So if you're chasing a must-win contract opportunity, go to our website, aockeysolutions.com, and click on Win. It's a tough market out there. Don't go it alone.
AFCEA has been bringing government and industry together since 1946. By joining AFCEA, you will reach the decision makers and become part of the discussion. You'll increase market visibility, gain market insight, receive discounts on AFCEA member services and events, and manage and engage corporate associates. AFCEA is the association of choice. Join today at www.afcea.org.
Since 1941, the USO has been lifting the spirits of America's troops and their families. Members of our military continue to make sacrifices and defend our nation. That's why the USO of Metropolitan Washington, Baltimore is committed to serving them throughout their years of service. USO Metro is the way for you to say thanks to our local military members, their families, and our wounded warriors and caregivers. Please visit us at usometro.org.
Okay, I'm going to ask the panel a question here, and I know it may require a generality and your best estimate or your best judgment, but here's the question. Are contractors at their workplaces inherently safe right now? Have we done enough to be safe, or are we safe enough? What do you think the situation is for our audience out there for the most part?
Let me just start off by saying that again, as I told you previously, Jim, I'm a compliance officer as well as general counsel. I have a law enforcement background. I think net, we're very safe.
Very safe.
Very safe. I think the incidence of workplace violence, the active shooter situation, is very, very small, almost minuscule. That doesn't mean that we shouldn't take preventative actions, okay, such as having an evacuation plan and having certification and training programs. But on a net basis, I think we are very, very safe here.
Okay.
I think government contractors are actually, in some respects, safer than the average workplace because they're going onto a government site. So you know, a lot of times you're going through a metal detector, or you're, showing a badge to someone, or you're badging into different rooms that you can't get in and out of. Whereas in a lot of workforces, you just walk up the elevator and go anywhere you want. So.
Okay, got it. Spiros, I want to turn the tables just a little bit on you and ask this question because it came up earlier. Let's say your government contractor directs you to remove individual X from the site. Are you obligated to do that? Are you bound to do that? Are you required to do that? Or are you exposed if you do that?
Well, you're exposed if you do, and you're exposed if you don't. The first thing you'd have to do is look at your contract, whether it's a prime or subcontracting agreement, and is the contract provide an opportunity for the customer to direct you to do that. The second thing is you have to be mindful of what we discussed with the ADA, FMLA, and whether state or federal laws that protect certain illnesses and disabilities. Having done that, put your customer on notice, saying, look, you've asked me to remove someone, but I think I've got a problem here.
Because it's going to violate the ADA,
it could violate the law. And ultimately, although you, the contractor, is responsible for your obligations to that employee, you want to work with your customer, recognizing you don't want to jeopardize your contract to find a solution.
And bottom line, no government employee can direct you to break the law, even if they say get rid of such a person, right?
Unless it's by contract.
I think as an employer, you almost would have an obligation at that point, if the government or the prime contractor tells you to remove someone, to go back and look at your own workforce to see if you can place that person somewhere else at another government site or on another government contract to avoid breaking the law.
What I'm taking from all this is that it's really tricky.
It's very sensitive.
Gray areas.
Very
I'll call it a balancing act.
It is a balancing
the one hand you want to comply, the other hand you want to protect.
That's right.
So what are some guidelines or thoughts on how you administer that delicate balancing act?
Well, I think there's two types of things you can do. One, from a operational point of view, increase your insurance policies, have umbrella policies, have an EPLI, employer practices liability policy, that protects against hiring and negligent retention. Also have a employee assistance program to have employees who feel they have issues to be able to call a number. That helps. Then
a hotline, for example, you know, an ethics hotline or something like that. I think you also need to train up your managers, like David was saying, you know, make sure that your managers know, like, how to spot the warning signs, how to see if someone's acting differently.
And in terms of what Lori is talking about, that training, the annual training, compliance program, sensitivity training like this, these are all very, very key. As a lawyer, as a compliance officer, the best proactive thing you can do as a manager is to train your workforce and sensitize your workforce.
Okay, so we've touched on these in various segments here, but I'll ask the question now for our audience's sake, I guess. What are some practical tips that you would at this point offer to our audience about how they can sort of, you know, walk that tightrope, that balancing act? What should they do to comply with the law and yet be safe? Any of you, please.
Well, again, training and sensitivity. Document number 2. I think you as an employer may need expertise in certain areas, whether it be disability law, whether it be employment law, whether it be contract law. I think you as an employer should not look at yourself as being isolated. You have plenty of tools out there. The final thing I have to say is practically you have to know your workforce. You as a CEO, you as a GC, you as a line manager have got to get out there and talk to your people. You have to listen to them and talk to them. And communicate.
Lori?
I was just going to say, you know, and before you make any irrational decision, make sure, you know, it doesn't hurt to place someone on administrative leave, paid administrative leave for 5 days while you investigate. Really do a thorough job to make sure that you've investigated, you've talked to everyone, you've really gotten the full side of the story before you make some rash decision like firing someone.
All right, well, as our audience knows, this show is ultimately about how to win or retain government contracts. So I want to look at this subject of workplace violence. Now, today, contractors in their proposals have to respond to management plans. The management plan often includes a health and safety plan.
That's correct.
My question, do you see a time when workplace violence prevention and response plan will be an evaluated factor or sub-factor in RFP, you know, or in contractor selection?
I don't. I don't. In fact, Lori and I were talking off camera. We think that a lot of the EEOC recommendations will be rejected by the courts. So again, I don't see this as being a critical component. Spiros may disagree, but you know, but I do think there is something called a reputational risk, and that is, you know, people that evaluate contracts, RFPs, are people like anybody else. They look at subjective factors, and again, if you're a company that has a reputation of having workplace violence incidents, it will certainly factor into your selection or non-selection as far as government contractor.
All right. Well, thank you. We're going to take another break for commercial now. Thank you very much, folks.
Thank you.
Good morning, my name is Alan Horlick and I'm the executive producer of Government Contracting Weekly, which is currently in its 2nd year on television. Now, as we move into a new year, I want to share with you some exciting news, and that is our decision to begin producing and airing commercial messages. This unique program attracts a pure concentration of both industry and government decision makers. As an advertiser, you can't afford to waste your money. So whether you are a contractor or a service provider, Government Contracting Weekly offers you the perfect environment and the perfect audience so you can make your own best pitch on why you should be hired. If you'd like to learn more about advertising in Government Contracting Weekly, you can contact us at governmentcontractingweekly.com and click on Advertise.
In this hyper-competitive marketplace, as a federal government contractor, now more than ever, you need to identify, track, forecast, and analyze opportunities that will help you grow your company by better positioning yourself to win contracts. I'm Jamie Bratton, the founder of Easy GovOps, and that's our mission. Utilizing the most intuitive market intelligence platform, Easy GovOps, enables contractors of all sizes to manage their pipeline, collaborate, and team like never before. Experience for yourself the power available to you and your team with a 5-day free trial period with no commitment necessary to begin. Simply visit easygovops.com to start your free trial today. Join the hundreds of other federal government contractors who are enjoying the ultimate competitive advantage of our unequaled market intelligence. Just spend one free week at easygovops.com and see for yourself.
Now, now, we're at that point of the time in our show where we like to hear from our viewers. So I'm going to now turn it over to Richard Nathan, President and CEO of AOC Key Solutions, and he's going to talk to us about the Government Contracting Weekly Mailbag. Richard.
A viewer asked me just last week whether in today's market it's better to be the incumbent or the non-incumbent when pursuing a contract. Incumbents have an advantage because they should, I emphasize should, know their clients' needs, wants, and biases. But often they don't. If you don't understand needs, wants, and biases, see our blog at aockeysolutions.com. Incumbents have a fair advantage because incumbency gave them an opportunity to perform in an outstanding way, earning the trust and admiration of their clients. But often they don't. They don't perform to that standard. Non-incumbents have the advantage because incumbents don't perform. When incumbents do that, they are leaving their house unlocked and inviting the competition to come in and steal their contract. So, unless the government is just plain tired of an incumbent, if an incumbent loses, it's their own damn fault. Jim, can I say damn on the air? Well, at Key Solutions, we're all about helping you win or retain your next contract. If you have a question, please visit us at governmentcontractingweekly.com and click on Inquiries at the top of the page.
That brings us to the end of this week's show. While our panelists share some incredibly important insights regarding what federal contractors need to understand in the critical area of workplace violence, I can only wish that none of you will ever have to put any of these lessons to use in a live situation. But as Spiros, Lori, and David have shown you, you must be prepared. So now I want to thank our panel. Dave Miller, the General Counsel from SkyLink, thank you for being here.
Thanks, Jim. Right. Great topic.
Lori Turner, partner with the firm of Eisler and Dare.
Thank you for having me.
Thank you very much. And Spiros, of course, welcome back. And you've been the General Counsel at C2 Essentials.
Thank you, Jim.
Good. Okay, so thank you, Spiros. Thank you, team. Most importantly, I'd like to thank you, our viewers, for once again making Government Contracting Weekly a regular part of your learning regimen. On behalf of all of my colleagues at Key Solutions, I'm Jim McCarthy. See you next week.
You've been watching Government Contracting Weekly, sponsored each week by AOC Key Solutions Incorporated. Government Contracting Weekly is the only television program devoted exclusively to the competitive and dynamic world of government contracting. For additional information, comments, questions, or suggestions, please write us at governmentcontractingweekly.com.